Sanchita, do you want to speak? No? Okay, no. Hello everyone, this is Sanchita Ain. I'm an advocate on record at the Supreme Court of India. We are going to discuss a very, very important topic today, how arguing in Supreme Court is different from arguing in any other court. So let's quickly start with our session. And we just were having a very good discussion with the attendees here, and some of them shared how they are scared of arguing before the Supreme Court. So we are going to tackle this fear one by one. So in this session, we are going to discuss how arguing before the Supreme Court is different from arguing before any other court. And in the rest of the sessions, we'll be actually preparing how to argue and what happens in Supreme Court, what can be the strategies that you can adopt, etc. So let's look at what makes arguing before the Supreme Court different from any other court. Planning the strategy. So I would first like to begin with what are the different stages in Supreme Court, because each time a matter comes to us, we first ask them that where is it right now, because some people come right at the beginning. So the strategy you will have for a notice matter will be different from when it's post notice. And I'm talking about the argument stage. Of course, while drafting, you've already drafted it. It's done. Now, if you have to argue for notice, then you know that you're only going to get a few seconds. If it's a statutory appeal, then you have a right to be heard, no problem. Then you don't need to prepare so much. So that's another aspect you need to keep in mind. If it's a statutory appeal before the Supreme Court, then you don't need to prepare much at the notice stage, because as a matter of right, you will be heard by the Supreme Court. But if it's an SLP, if it is any other kind of appeal under certification, or if it is even a writ, sometimes even to get a writ, get a notice issued in a writ also can take kind of, these days you would have heard a lot about the Article 32 controversy, but otherwise also when you have an alternate remedy. So suppose you're coming against an order of a high court, then in an SLP, then that remains an issue. How do you get notice issued? If you are coming under writ, but directly under Article 32, and you have not exhausted Article 226, and it's something that's pertaining to a particular state, then how do you invoke Article 32? Because the court is very likely ask you to withdraw it, and then first go to the High Court, then come to the Supreme Court. So under what circumstances would you then come to the Supreme Court directly? And what would you advise your client if they directly want to come to the Supreme Court because they have no hopes with the High Court, or say they are in a hurry, or I mean, clients can come under different circumstances and they really feel that Supreme Court will give them relief. In those cases, how do you pursue the case? How can your argument be different from any other, arguing any other writ, arguing any other petition for that matter? So that's something to be kept in mind. Notice, whether it's post notice. Now, if it's a post notice argument hearing, it can be on a miscellaneous day, it can be on a non-miscellaneous day. Even if it is not a regular matter, or even if it has not been admitted, then it can come either on a miscellaneous day or on a non-miscellaneous day. Then how do you deal with it? Is it any different? It's very different. So on a miscellaneous day, judges won't have that much time to hear you. And if it's something that's going to take a lot of time, then of course you would want it to be heard on a non-miscellaneous day when the judges will have more time to hear you. So it's not necessary always that after the notice is issued, the matter will be admitted. So once the matter is admitted, it goes in the regular list. But suppose it's not admitted and it's being heard as a miscellaneous matter, then also you can request it to be heard on a non-miscellaneous day so that you have more time. You may say that this issue is, it needs a lot of explanation, etc. And therefore list it on a non-miscellaneous day. Judges do pass those kind of orders as well. So you need to take those decisions way before the matter is called out, so that at the time when you're preparing, this is the first thing you're going to look at. Oh, this is a huge issue. It can't be argued tomorrow. Let's first request for a non-miscellaneous day, but still let's prepare for it. That's how it is. If it's for a final disposal, of course, you may not want it on miscellaneous day. If it's mostly final disposal matters are listed at the end on miscellaneous days. So you really need to take a call whether the judge will be that patient or not. So all of these have to be kept in mind when you are arguing, when you're planning a strategy, even before you start preparing for a case. So this is how it's different from any other court, where you don't have to think about so many aspects, right? At the most, at a trial court, you'll be thinking, okay, judge will be hearing it or not, whether the other side will seek adjournment, that's it. But here you need to also understand that at different stages, you need to have different strategies. And even the day on which it's listed can make such a huge difference. When it's coming up in the list can make a huge difference. And since there's so much at stake, you wouldn't want to take a chance, right? The next thing that you plan when you are preparing the arguments is which argument goes first and then which argument comes, right? Then, so again, when you're planning, so we'll come to how we do that, whether we start with the least important argument or we start with the best argument. We'll come to that in a while. What is the least you can get for the client? So again, when we are discussing the matter, when we're preparing the strategy, we also tend to see what relief are we seeking, and if the relief we are seeking is realistic enough from the perspective of what the Supreme Court has been granting, right? So if sometimes the clients may not realize it, sometimes the briefing counsels who come from other courts, sometimes they do not realize, they think, oh, this is something that we want and therefore we should get it. So we need to think of the far-reaching implications that it may have, and therefore sometimes we say it may not be realistic enough. We'll also talk about the far-reaching implications that we keep in mind when we are seeking relief. Just after a while we'll come to that. But right now, let's first understand that these are the various aspects you need to keep in mind. So you need to discuss this with the client and see that, fine, we are going to seek all of this, but now let me also see what is the least I can get, right? Which is that relief without which I'm not going to walk out of the courtroom. You need to fix that as well in your mind, so that when the judge is not inclined to grant you the kind of relief that the petitioner is seeking, you can still, instead of leaving your case and resting your case there, you can still keep persuading so that at least you can get that much of relief. You need to take the client into confidence beforehand that this is what we will at the most be getting, but I'm still going to try this, so that when at that moment when the judge is not inclined and you make that call, the client there is not surprised, or the briefing counsel is not surprised at why did you do this, because you don't have time to discuss so much. As in any other court, you won't have a lot more time to talk, to discuss, etc. But there the judge is dismissing and you have to take a call, and you as an arguing counsel, when you take such calls, then other people involved in the case should have a kind of indication beforehand. It only helps you. Okay, Flexibility in approach, again, as you would have realized that when you are doing all this, when you are addressing the court, you need to be a lot more flexible in your mind. You cannot be. That's why it's different when somebody who has drafted the petition argues and when somebody who has been briefed. You can really make out in the court that there's a difference there, that this person must have drafted it himself. They again, when people from lawyers from trial court or high court go to argue, they are way more passionate and sometimes they're very, very rigid about not giving up even a single argument. So I think that's not very advisable, and a bit of flexibility in approach helps when you're arguing before the Supreme Court. Now let's talk about the challenges peculiar to the Supreme Court hearing that you may not have in any other court. The first one would be judges have a way more to read. On miscellaneous days, they have so many files and they really skim through most of them or have their clerks go through them and prepare notes, etc. So the judges know the matter before they come to court. They're formed an opinion. Even for regular matters, sometimes they adjourn the matter, even if it's not a regular matter and it involves an issue that requires elucidation, etc. They like to read and come. They like to even read the law and come. They don't want to come blank and then you are informing and feeding them with what the law says. They of course they're quiet, they're listening to you, etc. But still they have an opinion in mind. Sometimes the judges will be vocal and they'll give you an opportunity to convince them, to make them think otherwise. Sometimes they have an opinion and they allow you to keep arguing, and then at the end you get to know what they had in mind. So different judges can be different in their temperament. Some judges may be interrupting you. You may not like the interruption, but it's an opportunity to allow you to improve upon your arguments, to take a different course, to explain them in a better manner. So these are challenges, but these can be used as an opportunity as well. This is, in a way, it can be opportunity when the judge has already formed an opinion in your favor. Then of course you don't need to argue. That's why sometimes you don't need to argue and the judges issue notice without you opening your mouth even, or somebody goes to seek a passover and the notice is issued. So it's not mandatory that you need to argue. You need to put forth all the points and only then the judges will take note of it. They can take note of it otherwise as well. That's how Supreme Court works. Okay, so there's some interesting notes, chat messages coming here. I'm excited to know about Supreme Court argument procedure and how to present the case. Right, so today we are going to do how it's different from other courts, and then in future webinars, we're going to talk about how to prepare for arguments in detail as well. I'm a student. Mukesh says I'm a student and it's scary. I can completely relate to it, Mukesh. When I was a student, it was scary for me as well. But the excitement of doing it at someday doing it, someday standing against a senior counsel and being able to do it kept the fire in the belly, and this is where I am today. So all the best, Mukesh, for it. So that's why we're having these webinars and workshops, so that you're more prepared, because as I was saying just before we started to some of the attendees, that some of them are never prepared, some of them are never confident. So how do we deal with that? Because these days even judges have started talking about it, that they really want the junior counsels to speak, to argue, and they know they can. They are the ones who prepare the brief and everything, but they're very reluctant to argue before the Supreme Court. So what can we do so that you guys are more prepared to argue before the Supreme Court? Is something that we are looking at and we are trying to work on it. So moving on, the judge, okay, I am very interested in, okay, Saurabh says, does experience or the knowledge, which is more important to win the argument? Well, 𝗬𝘂, experience and knowledge both have their own significance. You, of course, cannot do without knowledge. So if you're going to argue, it's not like the knowledge you already have when you are studying law. No, it's not that knowledge alone that helps. That helps. Basics help. But when you're preparing, how well prepared you are, how well researched, how good a researcher you are, how much you have worked. Just being good is not enough. How much you have worked on the case yourself. So even senior counsels, even after being briefed, some of them go through the entire file themselves. Some of them, so they all have their own strategies, but there's no one single senior counsel who would come unprepared for a matter. So you really need to be prepared. So that's why we will be doing webinars on how to prepare as well, so that you know how to prepare and then you prepare yourself. Then comes experience, and that's why we're sharing our experiences with you so that it can also help you. It becomes an added knowledge for you then. Second is asking how to interpret the judge's inclination about a case. Yeah, so I think it comes not just with experience, it also comes with your ability to observe, right? It can also be a skill that you can develop. For that, you need to practice. So even during your internships, when you go to courtrooms and you sit there and you wonder that why can't I get anything? So even if you can get what's happening, I mean, what the judge is thinking, and then how the counsel is able to change his opinion, etc. Even if you can get that, your internship is successful. Because when you start practicing, you really don't get as much time to do this because you have your own case going on in your head, how you're going to argue. At the most, what you can do, you can look at, okay, today the judge seems to be, it's post lunch, so then you have a different, you actually strategize. So that's there in one of the slides. So if it's post lunch, if you realize that the judge is looking tired, he may be a little impatient, then you need to be more and more patient with him. That's the strategy. They say, I think it was Justice 𝗿𝗻𝗃, who said that if your bail matter is listed post lunch, you are unlikely to get it. So in that case, do you seek an adjournment? Do you seek a short date? You don't do that. But then you have those kind of strategies that you may not be very conscious about. So these days I've started thinking consciously what I do or what I have learned by observing other people doing. And I'm trying to share it with you all. I hope it's useful. Do share your feedback. Ma'am, can you please point out 5 qualities a fresher must have to be part of Supreme Court legal fraternity? Okay, let me do a webinar on this as well. I can do this and then we can cover 5 qualities. Of course, there's a lot many you can have, but when you ask for 5, of course during this webinar we'll cover a lot of those points and you can see what those qualities can be that will help you. We'll be discussing this further in other webinars as well. Okay, so let's come back. The judge, I was talking about how the judge has already formed an opinion. It's not a good or a bad thing. It's just that you do it. I mean, it's a very, very natural trait we all have when we are reading something, even if we want to just get to know the facts or we just want to know what this is about. We are simultaneously forming opinions about people, even when they're talking. Your mind must be this. Now, if you start observing what your mind is doing, it must be forming an opinion about me as well. So it's a very natural trait that each one of us has. How do we play around? How do we work with it when someone else is doing it? Is the question. And how can you affect it? How can you do something about it so that it's in your favor? So that's something that comes as a drafting skill. So what can you do when you're drafting it so that the opinion is in your favor? What can you do when you're arguing so that you can change that opinion in your favor, even if it's against you? right? So there can be difficult cases where you already know that it's going to be difficult. Then what do you do, right? So next is, so yes, so if the judge has already come with a kind of opinion in mind that he's not willing to listen to you, etc., then of course you have the tedious task of first breaking up what's in his mind. So first understanding what's going on, right? So if somebody is saying, no, you're not making sense, then you would first want to know, okay, why is he saying so? So you would first listen to what the judge is saying. Once you've got where he's coming from, only then you start answering, right? So before that, if you just think, oh, the judge is, there's some people who have those kind of opinions also in mind, this judge does not understand, then you won't be able to address it adequately. So if you first understand why, sometimes it may be coming from, say you've come to court just before the examinations are going to be held, and of course you would need a stay, otherwise it will become infructuous. Now staying the examination will affect so many other people, so the judge may not be inclined to do that, right? So you need to understand this beforehand. The judge is more likely to act judiciously when it comes to Supreme Court. He's thinking of way many more things than any other judge of any other courts. So in that case, how do you approach, how do you tell him that, what I'm dealing with right now is way more important, and even if you postpone the examination by so and so days, it's not going to affect it's so much, etc., etc. How your petition to infructuous is going to, the kind of violation of right that would cause you, how much. So you also need to be able to argue on grounds of equity, etc., when you're arguing before the Supreme Court. You need to show how grave injustice it will be, etc., right? Okay, so let's move on. The judge knows what you're going to argue, right? So as we were discussing right now, that the judge has come. So I told you how there can be different kinds of judges. So there could be judges who will just say, oh, your matter is dismissed, you go, you're not making sense to me, right? So they may be showing you door even before you begin to argue. That can also happen, right? Or you're being constantly interrupted and you can't complete your argument, and you come out with, so much of the judge was not listening to me, how could I have argued? Then what do you do? Then there are times when the judge has formed an opinion. I told you that there are judges who would let you argue, but they're not listening, they're just letting you argue, and then once you're done, then they just say what they had already thought of, it was already there in their mind and you could not change it. Of course, they were listening to the extent that you had the opportunity of doing something about it, but you didn't realize that he had an adverse opinion, and that you could not change it till the judge says dismissed, throws away, right? Then what do you do? So these are the challenges we're looking at. Then we'll come to the different kinds of approaches through which lawyers address these issues. Yeah. So sometimes a judge may have a deep interest in an issue. That also happens, particularly in Supreme Court, where people come against violation of rights, etc. So there could be issues that judges are also reading in newspapers, right? Or there could be a legal issue they're particularly interested in. Say a judge has been doing, when he was a lawyer, he was doing a lot of arbitration matters. So he may have an opinion about all sorts of issues, and you are coming with one of them, and he would jump and he would be like, he would start arguing for the other side if he's not with you on that. Then what do you do, right? So how you stay in the game when that happens is what we're going to look at in a moment. Mehak is asking, ma'am, can we approach Supreme Court directly under Article 32, or is it necessary to go to High Court first? Right. So as a matter of practice, Supreme Court asks you to exhaust alternate remedies, and that will include Article 226 as well. So, so it's something. It's not like a written law, but this is a practice courts have been following, and it has been followed since a long time now. So you, but under exceptional circumstances, the court still allows Article 132 as well. So it's not mandatory to go before High Court first, but if it's only relating to a particular state, then it's likely, most likely, that the Supreme Court will ask you to go to the High Court first. And you are allowed to then withdraw the petition here and go to the High Court first. Once the High Court dismisses it, then you can come here. So whenever we get Article 32 matters, that's the first question we have in our head, that how are we going to get notice issued in this? After that, nobody asks you this question, but just how do you make your petition enter through that gate and say that, you know what, this is a fit case for 32. We couldn't have gone to the High Court for XYZ reason. It could be an issue that's affecting more state than one, right? So in those cases, the Supreme Court will definitely allow it. At least you can enter and argue your 32 petition. Otherwise, it's difficult. So this is another thing that we need to strategize all the time before we are going for 32, because sometimes clients, as I was telling you, sometimes clients are very sure that they won't get a relief in High Court. There are times when an writ petition on a similar issue may have been dismissed, so the clients are reluctant to move. So there could be so many reasons why the client does not want to go before the High Court first and wants to come to Supreme Court directly. In that case, you have to find a legal argument to substantiate it, to explain to the court why Article 32 and why not 226, because most likely otherwise it's going to be dismissed as withdrawn. They allow you to withdraw and then come back again, right? So, so how do you stay in the game is what we're going to look at. Points to keep in mind. So before we do that, first let's understand, how do you make your argument clear? Because if your arguments are not clear, then of course you can't make it happen. So I was giving you an example where the judge is allowing you to argue, but he has an adverse opinion in mind. You could not change it because you were not clear enough, and you never got an opportunity to even realize that you were not being clear enough to the judge. So how can you change it? Because ultimately everyone comes and argues the same. I mean, if any counsel would have come and argued the same points, right? It's only how you argue it that makes a difference. You realize sometimes when you're sitting in court and you realize that if this wouldn't have been argued, the judge may not have got it. So it's based on those kind of experiences that I'm sharing these points with you. Okay, so use of authority. Now, when you're arguing before the Supreme Court, you have to use a lot of cases, right? Why do you have to rely on judgments a lot? Because primarily you're looking at questions of law. Supreme Court does go into question of fact as well in SLP, etc. But primarily, these are the legal arguments you're making. You are not going into factual. You may go into issue, but still you're not going much into facts. You're relying, and even when you're going into facts, it's based on a legal position that you're trying to say that since this is a legal position, this is what has happened, therefore this impugned order needs to be set aside, etc. So primarily these are questions of law, and once you're able to show that the legal position was not considered by the courts below, etc., then you're through. So to get the legal position right, firstly, is important, and then to be able to convey it to the judge is also important. How many to use, how to use, these are all important questions that we are looking at when we are arguing before Supreme Court. Using and distinguishing. So it would have been very simple if the legal position is in your favor and you can find the case, you can just go and you can, even before you start arguing, the judge would know, right? But there could be situations, and mostly it is so, that you need to distinguish. There would be some case somewhere that the other side would be citing, and then you need to distinguish and point it out how your case, the facts of your case, fall squarely under certain circumstances, and therefore they need to be treated differently, etc., etc. So either you're saying that the law is not settled as far as your facts are concerned, or you're trying to say that X case is which is in your favor, it is what covers the facts of your case, and not Y case that the other side is relying upon, etc. So you need to distinguish at various levels in a clear manner, so that the judge can be persuaded. This is a quote from Legal Reasoning and Briefing. It says, much depends on the advocate's ability to make the case talk, right? For many lawyers do not argue a case, but merely cite it, a difference far-reaching in its effect. So you will find some lawyers would just say that this case and they hand it over, right? But they don't really push it. They don't know which part, how to read, and should they even go through it, right? They'll think the judge will read it, etc. So that again is very important. You would see senior counsels take them through it. So even when they're arguing, they know at what point they are going to read which part of the impugned order, then next what they're going to read. So each time they're arguing, they're also relying on something and they're reading it. They're making the judge go through that part, right? So that's again very important. So even when you're relying on cases, it's very important to make them go through it. It really makes them get it. So even if you say it in as many words, the impact is not so much as when you make them read it. Even during briefings, I have observed this. You make the senior read and doesn't go off his head. You just tell him that this so-and-so case says this. He may again come back to the same point and ask you the same question. Again, you have to tell him, oh, so-and-so case says this. So making them read becomes very important. There are three ways in which judgments can support you. So either you have a binding judgment with you, no problem. So binding judgment would be any Supreme Court judgment that's in your favor, no problem. On the same issue, same facts, no problem. Different facts, the other side will point out the facts are different. You need to then show how, even if they are different or they are not different, it's in your favor. The second kind of judgment would be those which are persuasive in effect. So it could be an obiter in a Supreme Court judgment that you are relying upon, or it could be a High Court judgment. It could be High Court judgments also. So they would only have persuasive value. They won't have binding authority. So if you don't have any judgment of Supreme Court, those judgments can also be relied upon. Then there can be judgments that are analogous. So as I was saying, that the facts may not be exactly the same, but you can still rely upon them to make a certain point, right? The other aspect would be difference in how you refer to. So I was talking about making them go through it, yeah? So, but there is a difference in how you refer to well-established propositions, landmark judgments, and others. So if you're relying upon, say, Maneka Gandhi for right to life, etc., you know, I mean, the judges also know it was laid down there, etc. So you don't need to read from there in those cases. Only if a certain paragraph will have a very persuasive effect on the judge, if you really read it, right? Like in the linking of Pan with Aadhaar before Justice Sikri, we read his own judgment to him, right? We read Nansa to him. Ma'am, can we take the citation of the Sessions Court in Supreme Court? They don't tend to have very good persuasive value on the Supreme Court, but if you can, but if the order of the Sessions Court has been upheld by the High Court, then of course it's in your favor. You can use that. So it may not, it's not necessary that it has to lay down a principle, even if you can show that in these circumstances, this is what the court did, that should be enough for you. Of course, the best judgment would be if it's of Supreme Court. Otherwise, you find of various high courts, and if you see that there is a uniformity in how they have decided a certain case, then that can be in your favor. Yeah, so to that extent, you can find the high court judgment if it has been appealed against and then use it. You also need to find, if you are finding high court judgments, you also need to find if NSLP had been moved, if it had been dismissed. All this will have an impact on your case. Okay, structuring your arguments. So now we have planned the strategy. We also know how we are going to use the authorities. So now let's see how we structure our arguments. So I'm talking about when you are arguing it. So of course, when you're preparing, you're also doing the same thing, but even when you're arguing it, you are using signposts. So signposts are not just meant for you to refer to. You actually tell the judge. So signposts would mean when you're traveling, what do? You look at signposts, particularly when you are going to an unknown destination. Signposts help, right? So you know where you are going, you know how far it is, right? So you start your arguments by telling the judge that you are going to argue this, right? You have these many points, right? And then you start telling him, the first point will be, you give a crux of it, and then you start arguing. You'll see each time you do that, the judge is tempted to note it down. It makes it easy for him. It makes it easy for you, because then the judge won't miss any point. There's something that he can refer back to. He just has to note down a kind of a heading, right? Point 1, okay, this. Then sometimes he may forget to write a certain point. He may ask you, oh, what was your point 2? So he writes it. It helps. Even during your arguments, even if you're going to file your written submissions later on, while he's listening, it helps in his listening to know that you're going to argue these points. This is where you're taking him, right? Okay, so there's another advantage of signposting actually. Particularly when the judge is not convinced when you're arguing. Say the judge is kind of saying that, no, this argument doesn't make sense. So you tell him that, you know, these you are going to make 4 points, say. So he'll wait for your next point. He won't outrightly dismiss the petition. Okay, thank you, Mukesh. Right. So style of arguing, let's also talk about style, because it's a bit different when it comes to Supreme Court. And once you enter, you'll realize that that may be another reason why you feel, you know, scared or whatever, because people are following a certain pattern that you are not used to in other courts. So let's understand what those patterns are so that you can also inculcate. Is it good to tell the total time to be taken to complete the issue? See, sometimes the judges themselves ask you how much time did you take. Then you say, 2 hours, half an hour, whatever. But for each issue, it's very difficult to demarcate that this much time I take. So that's all right but you should have a sense of the total time you're going to take so that you can point it out to the judge. If he says if it's too late in the day, then you yourself should be saying that, you know, I'm going to take this much time. And it's not a bad thing to do, right? It's not a bad thing to take more time, but just that you need to be clear about the fact that you're not wasting anybody's time. Right? So speak with conviction, that's very important. Even your eyes need to have conviction. I always say that if your eyes don't have conviction. So I've developed this habit during virtual hearing. I have developed this habit of looking into the camera and talking. It helps. So have conviction, not just speak with conviction, have it, right? Have it in your body language too, that helps. So even if you have to fake it, but you need to have it. Just like artists do. I mean, I was just wondering, how do they do it? Even if they are having a bad day, they look fine from head to toe. So even if you need to fake confidence, you need to do that. when you are in the Supreme Court, because I understand you will be scared, etc. But then still speak with conviction, fake it till you make it. You need to be a powerful speaker. You would see that those lawyers who speak powerfully, even if they're young, it doesn't matter. You don't need to be a senior advocate. You don't need to be designated to be able to speak powerfully. That's one thing you need to distinguish, because what happens is it's not like you will go there, you'll reach somewhere and then you start speaking powerfully. You start speaking powerfully and then only you reach there. Command over language for Supreme Court, it's English. You need to have command over language, otherwise you're both things. It may be unfortunate, but that's how it is, because you yourself will start feeling less confident if you do not have command over language. If you start feeling less confident, it would seem as if your case lacks merit. So that's why it's all connected. Therefore, it's important to have command over language as well. Argumentative vigor. So when you argue, so when I say speak with conviction, I also mean that what you speak, the content also needs to have an argumentative vigor, right? So your style needs to have it, your content also needs to have it. Not just eloquence and oratory skills, that's something you would know, but ability to apply sound logic and legal principles to the facts of the case. So that's again very important. You need to be able to do it right there. Sometimes the judge may throw a question to you, etc. That would require you to apply your mind right then and there and do it. So being able to comprehend is very important. Something that I've noticed is it may be lacking in some of you when you are studying. So I think a good exercise would be to read judgment and then try to comprehend. It's easy for some people, but if it's not there for you, if you find it difficult to apply principles to facts, then I think this can be an exercise you can do, a kind of comprehension exercise where you read and then you try to comprehend it or try to think in your mind that what did I just read, and if you can see, if you can then apply it to end the case and see why these two cases are similar, etc. So that can be a useful exercise to do when you are a student rather than just reading a case. Okay, Bhupendra has a question. Filed a contempt petition in Supreme Court as party in person for implement judgment of so and so in same spirit and letter. Okay, wow, Bhupendra, so good to have you here today. So yes, enforcement again is a problem. For that you need to have strategies as well. So contempt is of course definitely one of them. Quick and accurate when the judge asks a question, that will happen only when you have that kind of presence of mind, not at that moment, but an ability to analyze and apply principles, etc. Illustration and anecdotes, they really work well in the Supreme Court. So rich and interesting. So that's in the point that's quite connected. So you explain them with examples, etc. You don't shy away. Sometimes young lawyers find it difficult. So if you ask them to explain something, they will explain it and it will be very, very rich. But when they go there to argue, they become like robots and they just say what they have, So they may be very sketchy, etc. So it helps to break that. I think as every one of you were saying that it's about fear. So if you can break that and you can make it rich and interesting, once you start enjoying it, they'll start enjoying it, then your fear goes, you get a good order, you have confidence, etc. So it's all related in a way. Different approaches. So now we're coming to the different approaches that successful Supreme Court lawyers have been adopting. Okay, Sarjan, rich and interesting would be, so how can you make your argument sound rich, right? Rich does not, so rich could be that you express it in a manner. So some people have that skill, that they use words in a way that that's really mesmerizing and you want them to keep speaking, right? So the judge also doesn't ask them to stop. They're like, no, go on. Wow, this is so good, because they can really appreciate. By the time you reach there, you can appreciate these things, right? So it doesn't mean flowery language, but the way you use your words, that can make it rich. Or what can make it rich? Illustrations can make it rich, right? Your own examples, anecdotes can make it rich, right? The way you narrate your client's version of the story, that can make it rich. Right. Could you explain on the point about having signposts? We are coming to that. So when I would be talking about different approaches. One of the approach would be how they use signposts, how the Supreme Court use signposts when we come to in a while. Right. So one of the approaches, one of the ways the Supreme Court lawyers. So you remember we were talking about challenges when the judge is not convinced, etc. Then what you do. So it's part of that. So how? Okay. So there's an interesting question on what level of voice modulation is expected. May it be a high tone when stressing a particular point of the matter, or is it contempt of court? Right, this is a good question. So you're not, I did a voice training workshop with the singer, and that really helped me because she differentiated that for me, that I had differentiated for myself before, but I didn't know the words to use, etc. So there's a difference between your pitch and the, I think it's called tone or whatever. So even when you would see theater artists are whispering on stage, you can hear them. So in the act, they're whispering, but you can hear. So they have not raised the pitch. When you raise a pitch, it sounds rude. It sounds bad to the ear. But you can raise your voice, but not the pitch, right? So that's something that can be practiced, that you don't raise a pitch. You raise, I'm forgetting the word for it. So so that the way the singers would sing. So you have even so you don't need to be really loud to be heard, right? So you can kind of expand your voice and you can practice that kind of speaking, that they don't find it rude, right? So emphasize, of course, it's important. Voice modulation is important. You've seen lawyers doing it. But voice modulation would just mean, it doesn't mean that you're screaming, because that really does not help. That's very unpleasant to hear as well. How to distinguish? Well, if I tell you, I mean, I have Sargam in mind and I really want to tell you how to distinguish. But if you don't want to go that way, you can go that way as well. That when you speak, where's your voice? Is it knee? Is it where? Right? But if you don't want to distinguish it that way, you can still practice. You can keep watching yourself as you're speaking, even in your daily conversations. Does your pitch go high? Because if generally your pitch goes high, it's very likely that you'll get excited in court and your pitch will go high again. So I had to work on it. I got to practice in lower courts, and now I have developed this habit of not raising my pitch. But even if in daily conversations, people may know I raise my pitch, but in courts, it doesn't happen. And what happens is, with practice, and I don't have to now consciously do it, there is a kind of, my voice is loud, but it's not shrill, right? Perfect, let's move ahead. But I'm so tempted to do the voice training exercise now, because it can be very useful for lawyers. Thanks, Udeshan, that it helped you. Okay, calmly making your way one point at a time. So one thing, again, it's all connected. So when you're speaking at a higher pitch, it's likely that you're already impatient, you've already lost your calm, and that's why you're speaking in that voice. Or if you are that shrill, then it's very likely that you will lose your calm and you will start talking fast, right? So one approach that Supreme Court lawyers, and you would find it across the board, is they calmly make their way. It's easier to make your way when you're calm, right? So even when you'll see a lot of theatrics happening there as well. So you will see some lawyers, I'm not naming them, some senior lawyers are really can be very loud at times, but that's part of what they're doing. So they're doing it very consciously. You will hear Mr. Saleh, you'll hear Dr. Singhvi. They intentionally do that at some point, right? But it's very intentional. They know what they're doing. The judge knows what they're doing. So, but they're calm in their mind, they're calm. So if you can do that, if you can be good at your theatrics as well, that you're calm inside, but you are projecting something that can be good. I mean, there's some people who have used it very well, particularly when the other side is getting agitated, right? And now you realize that if you don't forcefully put your point forth, then it's going to be your loss. So then what do? Particularly when everyone, like in an adversarial system, what happens? Like people are very, very agitated, they take things personally and they really want to fight it out. Then what do? You still stay calm, right? That's the key. Okay, the next aspect is flexible approach. So when I say calm, I really don't mean that you should not be forcefully making a point. If the other side is losing their control, then you also need to match it in some way without losing calmness, is what I'm trying to say. Flexible approach, malleable, ability to adapt, yet standing tall, right? So even when you are giving up on a certain relief, you're saying, okay, fine, you're not pressing it, but you're standing tall, you know that your client still has a valid claim. That's important. Laying your foot firmly on the ground while presenting. So that's another aspect that you need to keep in mind, that you need to be convinced enough. You walk, stand, talk with conviction. That's very important. First getting the attention of the judge, then elaborating. So if you miss that, you don't get those few seconds back, right? So you may be talking for several minutes, but you've missed making that impression in the first few seconds when the judge was really eager to listen to you. So that's when you need to hit, and you need to really plan how you're going to start it, how you're going to open it. Only then you can get his attention, then it's easier to hold it. Okay. Are there questions? Can we question Supreme Court's judgment? Make question again, of course. Overruling is possible, so it has to be done by a larger bench. If a bench is doubting it, and that happens, then it gets overruled. So to that extent, yes, but how you argue it, how you present it is something that's, so you don't really, so what happens, how there has to be a basis for doing so, right? So the basis could be another judgment. So in that way, you are questioning a particular judgment based on another judgment. Say that was pronounced before this judgment, you can always say it's in curiam. So all that's possible, so long as it's legally based, it's based on law, it's possible to question. Okay, is it good? Okay, this question had already been answered. May I get the PPT slides presented by you now? Yes, you can get the PPT slides on YouTube. It will be there till the time digital memory allows. So you can get it there. Quickly assessing how much the judge already knows, right? So one thing that we were talking about right at the beginning was this was one of the challenges. So this is how the lawyers approach it. What they do is the moment they begin, you know the judge has read. How much has he read? You don't know. How much has he formed? You don't know. So if you start elaborating all the facts, etc., then the judge may lose patience, right? So you need to quickly understand how much he already knows, and then you take it from there, right? So So one of the things that you need to do is you need to have 2-3 versions. So we'll come to that. When you're preparing notes, it's better to have 2-3 versions of it, I'll tell you. Okay, the other approach is simplify. Mukesh is saying really as a mother, baby steps learning process from you, ma'am. Thank you, Mukesh. This means a lot. Thank you. No, that's the whole purpose, what I have learned through my experience to give it to you. That's the purpose. Thank you for acknowledging. Okay, so the next point is simplify as much as possible. Make it look simple. It really helps. So this is how Mr. Rishi does. I mean, he tends to always start with this is simple. This is simple. The moment you even say this is simple, it makes it simple, right? And I remember the other side, the senior got so agitated. He was like, no, this is not simple. This can't be this simple. So make it simple. You don't just say it's simple. You actually make it simple. You make it assimilable to an extent that it's so easy to understand it that the judge is with you. That's one of the ways of doing it. So this is where signposting helps. It helps to make it simple. When you begin with, there are just two issues to be considered. And the judge is already like just two. Yeah, right. Fine, just two, right? You've already simplified it for the judge, right? Not by saying two issues, right? But also by saying just two issues. Then when you say, I only have two submissions to make, again, you're making it simple. Then he notes, he has the he finds it easy to write it down. Okay, number one, what is the number one? What is the number two? Right? It's easy for them to grasp. It's easy for them to note. Thank you, Mehak, that you're finding it useful. There's no risk of them missing out. As I was telling you before, it's easy for them to recall, etc. Even later on when they're writing the judgments after reserving it, it's very easy for them to have a look at it again. There's nothing better than having your own notes. So that helps. Okay. Next is that you passionately put across a certain point to get the attention. As we were talking about voice modulation, if you can emphasize one point more than the other. So that's what I was talking about. Some lawyers use it as a strategy. They already know which point they are going to hammer, right? It can be the opening, something that would make the judge listen to you. Particularly if you're, I don't know when I wrote this, particularly if you're young or you look young or it's a miscellaneous day. Yeah, so these factors do have bearing on how you argue as well. So I think it will be really, really important and interesting if you can make your argument interesting and see how the judge will be very impressed. If you're young and you make arguments in that manner, the judge will be very impressed. Just that people are scared of doing so and therefore it does not happen, right? Keep it interesting with anecdotes. I told you that. I mean, that's what lawyers do. I mean, that's one of the skills you need to learn, how to keep it interesting, right? If you think you don't have good oratory skills, and it's still possible to survive, it's still possible to be an arguing counsel, trust me. Write down every word you would want to argue, make it as interesting. So this is an exercise you can do. If you don't have good oratory skills, you write down everything you have to argue, the way you will be arguing, everything, every bit of it, which point you'll emphasize upon, what will you do where, etc. All that you make note of, you practice, you rehearse. You can do it in front of the mirror. If you're scared, etc., do it in front of the mirror. Write everything down, practice it. There's nothing wrong in doing this. Once you get there, then it will come to you. You do a few hearings, it will come to you. But before that, if you're not sure, be prepared even for this. Write down everything, argue, prepare, argue, prepare. That's how it's done. Addressing, not necessarily countering beforehand what may be argued by the other side. So one thing that a good smart lawyer would do, because he does not know that whether the judge already has been forming an opinion, has counter arguments in mind, the person does not know what the other side will be arguing, but has a sense, right? You realize you can be your own devil's advocate and you know what the other side is going to argue. So you very smartly address it, even if you don't have to counter it in as many words, because sometimes if you start emphasizing too much upon, clients tend to do that. Clients come and tell you, or sometimes even briefing officers come and tell you, but this has not happened to us, so you need to say this has not happened to us. This is not. If you keep saying that, it will seem like there's something wrong about what you are saying. So therefore, not really emphasizing or countering, but addressing it very smartly helps, so that you're taking into account that as well. You're trying to say, yeah, yes, it's understandable that this is how it's to be done, but in our case, this has happened, right? So you have already taken into account, you have already addressed. So the moment the other side opens the mouth, the judge will be saying, no, but in your case, this has happened, so why shouldn't we consider this, etc. So the judge is already on your side just because you managed to address it. Practicing in front of mirror is a good option. Thanks again. Thank you. Please tell us whether English language is only used in courts or the regional language. So as per the Supreme Court rules, English is the language of the Supreme Court, so it has to be English. Okay. High to low, low to high. This is another thing that lawyers prepare beforehand. It's not always necessary to start with your strongest argument, right? So you can have different kinds of strategies in mind. You may start with the weakest argument. You know it's going to fall, and you keep the strongest for the end. Or if the judge is not listening, you quickly bring that up so that he starts listening, etc. Because once you've made your strongest point, then he may not be listening to other points. There can be different strategies for different cases, but I'm just telling you that it can be both. So you need to think if it's very strong, then what you do, and if it's very weak, then what you do. Building your, so some people would build their case gradually, first by narrating facts, giving their own version, very brief, crisp version, followed by the weakest point, and then slowly building it out. So finally, when you make the strongest point, the judge is with you, but that's just one of the ways. Niyati is saying, in future, I want to give AOR. Before giving that, I have to work on the Supreme Court lawyer who had given that exam. So my question is that, can any lawyer allow me to work under him or her for 1 year? I'm asking this because I don't know about anything. Okay. So you have to do this 1 year training under an advocate on record with minimum 10 years of standing as an advocate, right? So you have to find basically an old advocate on record. But it's also possible to get a commencement certificate and a completion certificate. While you are also doing training, you can do other stuff as well. So that's possible. Sometimes you may want to begin with a simple point and gradually make, as I told you. But when you do that, again, so when there's a risk when you start with the weakest point first. So you need to first tell the judge that you're going to make X number of submissions, so that even if the judge is not persuaded by your first point, he will wait for your next submission, right? Okay. Going back and forth, sometimes they leave one point if the judge is not persuaded, they come back to it again once they've explained the entire context, so they can see why the judge is not getting it, and then they prepare the context for the judge to get that point better, and then they come back, right? You need to know which is your winning argument. So you need to have one winning argument. You need to know the central theme, central point, one argument that will sail you through. So why you need to do that? Because even though you won't confine yourself to just that argument, if you do that, you may really not sail through. You need to have other arguments as well. But it would give you clarity on how much to emphasize upon which point. So if the judge is not convinced with one argument, you can leave, you can go to the next. But if it's your the argument, the winning argument, Then you don't stop persuading. Then you use different approach to get his attention, to change his mind, etc. Right? So that's why it's important for you to identify beforehand. Okay, depends on, I told you about this, the Justice Badr Ahmed had once said that if your bail matter is listed post-lunch, it's likely to be dismissed. So you need to keep that in mind. If it's towards the end of the board, if it's on a miscellaneous day, you need to go beforehand and sit in the judge's court and see what's happening. Is he listening? Is he being patient? Now, just before your matter, what's happening, right? So you need to be in the courtroom way before your matter is taken up to know the difference and tailor your argument accordingly. So when you're observing it, you're also planning. If he's not listening much, then you don't go into facts so much. Then you may have a different strategy altogether, just observing the proceedings before yours, right? You can make it crisper, etc. You may want to make it more interesting, right? As I was telling you, flowery language is not necessary, but how you present the case is important. On many occasions, okay, sometimes there may be surprises. The judge may start, giving a kind of opinion that you had not expected. Then what do you do? How do you stay in the game? So if you're expecting the judge to be patient, you need to be patient too, right? So you don't interrupt the judge. You don't start with no. So this is how, if you are agitated, then you agitate the other person as well. So these are the things you need to keep in mind. Okay, so we were talking about being flexible. We were talking about how you need to discuss with the client what will be the realistic relief for a case, but you don't stop pressing still, right? So, but at the same time, you tell them that this, at some point I may not be pressing this, because it's better to get something than get nothing, right? So you can choose not to press a certain argument or a relief. So the briefing counsel, the person who's drafted it, they all may want you to press all the arguments, all the reliefs, etc. But you may take a call. You may take a call then and there as well. It does not mean that you're on the wrong side. It only shows you're being reasonable, right? You need to be reasonable with the judge as well, and it's your call when you're arguing. Sometimes not pressing an argument can also change the course of thinking of the judge. So it is in the way of giving direction to the course of thoughts of the judge. So sometimes it can so happen that it puts you more under control of what's happening by just not pressing. You are taking the lead. You're again bringing it back to yourself that fine, I'm not pressing this, but this still I want, right? This still I need. So therefore you start focusing on other arguments, other relief, and you're like, it's fine, I'm not pressing this. Let's not look at this relief at all. Let's just confine to this. So it's easier to at least get those than if you're sticking to everything and you're like, no, but you're being righteous about it. And you're like, no, but this is an argument. I am going to make it. This is a relief that I want, and therefore I seek it. Then it's likely that the judge will be annoyed and you're not going to get anything. So sometimes it may be smarter move not to press a relief even when it's part of petition, so you can start. It does not mean it's not pressing, right? It only means that you're being clever, you're letting it go, etc., etc. But you can still start with it. You may know already that it's not going to make an impact, etc. And then the moment it's not, you very slowly and calmly you start focusing on other points. Or you say it in as many words. If the judge is not inclining, he's so focused on a relief that's so unrealistic, then you have to say it in as many words that you're not pressing it, so that he can focus on the rest of it, right? That's possible. So preparing notes, when you're preparing notes, again, even for yourself, you keep it simple. That's how your arguments would remain simple. You carry a simple version of the list of dates. So the list of dates in your petition will have all the material facts with the list of dates, right? But when you're preparing notes for yourself, it will have only the relevant facts with you, with the relevant dates, only those on which something will turn on, right? But you still have the list of dates. In case you need to refer, you can always refer to them, but it's important to have a simpler version with you so that you can just point those out, and then you can start your argument, etc. You prepare 3 views. I was telling you that you need to prepare kind of so that if the judge already knows certain facts, then you switch, right? So you have a kind of panoramic view, you have a bird's eye view, you have a cross-sectional view, right? So you have a detailed kind of facts narrated there. You've already prepared for it. It's not like it's written somewhere and you're going to read it from there, but you're prepared to present it to the judge because the judge may not know anything. So you're prepared to present all the facts in a story form to him, your own version, your client's version, right? You've prepared that view as well. Then you've prepared a kind of, I was telling you about just the relevant facts, you've prepared that as well. If the judge is clear about that, then you just kind of start with the argument straight away. So it's important to have all sorts of views. And you also need to switch sometimes. When you're presenting, you realize that this part judge knows. Then you switch. Sometimes you realize, oh no, the judge is confused. Then you have to switch to the panoramic view. You have to start, you start from the beginning, then you give them the whole picture. Sometimes you may think, oh, the case was just 2 days back, the judge will remember. The judge doesn't remember anything, but still seems like he remembers, right? So you start arguing and then you realize, no, I need to go back. I need to tell him all these facts. He's not clear about it. So you go back. So for you, it's very important that you have all of this ready with you so that you can switch between different views, right? What to do when the judge does not agree with you? Okay, stay calm, right? That's exactly when you should not lose self-control. It would affect your ability to think. Don't interrupt. Let the judge complete what he's trying to say, right? It only gives a better idea of what is exactly going on in his mind. As I was telling you before, that you really need to get where he's coming from. He may have the future implications in mind. You won't know unless you allow him to complete, unless you're listening to him, instead of thinking, how do I come to him now, right? Right. Take a pause, understand where the judge is coming from, appreciate it, acknowledge, validate before addressing it. Don't begin with a no. So this is one thing that these days when I speak to any authority for that matter, this is how I talk. I'm like, you're right. You're absolutely right. But, like that. So you acknowledge, you validate, and then you address it. Even if what you're saying is exactly opposite, even if you want to say you don't understand, you don't get it, you don't say it. You begin with you're absolutely right, or you say something of that sort, so that they feel validated, and then you start, right? Then you figure out how else can you present your argument. So you don't keep repeating. If he's not getting it, means you need to do something about it. You either get why he's not getting it, either you get that, oh, he has something else in mind, you address that, say future implications, etc., or you elucidate, you tell him how the basis of your argument is different from what he's saying, etc. So distinguishing it can also be one of the ways of doing it. Or you change your approach and you start showing him the repercussions that it will have if your client does not get relief, etc. Point the impact it would have, etc. Repercussions, as I was saying. Give analogies, describe scenarios, describe it in a manner that's easy to imagine. That's the storytelling plays a very, very important role as a skill. So, even when you're explaining the repercussions, just saying it and explaining it as vividly as would, he would have a imagery in mind. That's important to do. You need to be good at invading the thought process, and that's a skill, right? How you do it, so it's without getting agitated, without losing your cool. How do you invade someone's thought process in a way that they don't even get to know it, right? Switch to the next point, come back to it later. I told you how even the good senior lawyers do that. Don't take it personally. Don't make him take it personally. That's a very bad thing people do. A bit of anticipation as to what kind of doubts the judges may have in mind helps. right? So then you're prepared for it, that the judge will have this, and this I need to address. So even before he expresses it, it's possible to address it, or when he starts talking about it, then you know the different approaches, as I was talking about, that you can explain like this, can explain, so you have all of that in mind, and then you start adopting different approaches to address his doubt, right? What annoys the judge? Okay, I only have 5 more minutes before the next webinar starts, so let me make it fast. Making personal remarks. Oh, I have 10 minutes. That's good. Okay, making personal remarks against fellow advocates. So these are some of the etiquettes that are peculiar to Supreme Court. You can say that because if you are practicing in lower courts, it may be a little different there. But when it comes to Supreme Court, people do the same thing gracefully. So you won't find people making personal remarks against fellow advocates or belittling lower courts. It's so even when you're saying that the court should not have decided what they have decided, and not getting personal, and you're not saying that the judges don't know anything and stuff. So you're being graceful. I think that's the basis of all the etiquettes that professional etiquettes that Supreme Court lawyers follow. And since judges are also so used to it, you do something different, it can really backfire, right? It makes it seem you don't have a strong case on merits. If you start being that aggressive and personal, it's not good for your case, it's not good for you. So it seems like you're resorting to petty tactics. So what may work before trial court, in trial court, not work in the Supreme Court as far as these kind of tactics are concerned. It should not be, so whatever you say, it should not be perceived as an unfair remark against anybody. So just do it with grace, and even if it's a nasty remark, you can gracefully make it. Don't just take it, give it back as well, but do it gracefully, right? Attacking the court never helps, it doesn't. Keeping future implications in mind. So this is what I was talking about. So judges in Supreme Court always have future implications in mind. So even when, as a Supreme Court lawyer, you are arguing, you need to have future implications in mind when you're arguing a case. This is one of the doubts I was talking about that you need to keep in mind. You need to be able to anticipate what the judge will think. If you're asking, for example, I was giving you an example of seeking a stay for an examination, it's going to affect so many people, etc., etc. Tomorrow, somebody else will come with the same kind of issue. Then what happens, etc. So you need to keep all that in mind. You need to be able to address all of it. This is one aspect of it. The other aspect is when you are arguing, say, a writ petition, you're arguing a case of violation of right, say whoever was arguing 377, etc. So you do it with a sense of responsibility. You know that it's going to have a far-reaching implication. So therefore, that also makes it very different from other courts. And not just that, not just the issue being big enough, not just the issue affecting so many people, but it could also be that what is written in the judgment is going to have a precedential value, right? It's going to be followed by high court, by lower courts, everywhere, tribunals everywhere. And you play a very important role in what is being written in the judgment. What the submissions that you make are going to be recorded there. Not just that, the judge is going to form an opinion based on that, and based on that, the judgment is going. So it's going to have an implication on all of it. It's going to have an implication for generations to come. So therefore, I think it's also important that you do it with that sense of responsibility, that if you keep it very abstract, etc., then it does not help the future generations. That's one of the things we kept in mind when we were arguing triple talaq. We thought that the judges should not decide certain issues, and therefore we moved an implement application asking them that only this should be decided, because if you decide this, it will open Pandora's box. Then even when we were focusing on the reason why we moved an implement was because we really wanted the law to be laid down properly. So this is also a responsibility that Supreme Court lawyers do have on them. And even when we read 𝗬𝗪𝗧, when we read all these judgments, we realize, I mean, it makes such a huge difference. These judgments will have such a huge difference. The way constitutional morality is explained will have a huge difference. In future, how do you then argue those cases? How do you rely on 𝗬𝗪𝗧 then? How do you have your own explanation? How do you then go to court and use constitutional morality? All these are going to have implications in future, right? A clear conceptualization of what you're seeking would involve clarity on every aspect of it, including repercussions. So I told you that's a very, very indispensable part of your argument, to say that this is, if this is not done, then this is going to happen either to me or others and the society at large, etc., depending on what the issue is. Larger picture, you need to keep the larger picture in mind, because judges always keep the larger picture in mind as far as Supreme Court is concerned. Repercussions it will have in future cases, I already told you that. Third party interests. Third party interests would be, say, these days you would have read, I mean, when governments, I think there's a recent judgment when the government had approached quite late. It keeps happening all the time. So when when you file a petition so late, then by then third party interests have been created. Then what do you do about them? It creates a bad precedent if you condone those kind of delays, right? So if your client has done that, then how do you argue so that the court is inclined to condone that kind of a delay? So either you say that the delay was so justified, or you say that nothing will happen if you condone the delay, no prejudice will be caused. So you need to keep all of these in mind when you're preparing your arguments before the Supreme Court. So this is for today. We have these workshops coming up. One is tomorrow. I'm doing it with Abhyuday on how to brief a senior advocate at the Supreme Court. It's from 6 to 9. So this will be a very, very elaborate kind of session where we will train you to brief a senior advocate, because I have worked with Mr. Salman Khurshid. I've seen so many different styles in which briefing counsels brief, and some have been so effective. Some have made an impact, and I've seen, I told you how I observe things, and I've seen how they have had an impact on the way the matter was argued or even the outcome. So based on that, I have kind of created how it can be done, and I'll be leading a training session on that. So if you are interested, you can come, you can register. I'll just show you how to register. These are the other workshops. You'll find them on the LawSikho page as well. Webinars, I'll be doing a lot of webinars. So please do attend if you are interested, if you want to practice in Supreme Court. These webinars may be useful for you. So I'll just stop this here and I'll show you how you can. So first, let me show you how you can register for these workshops and webinars, and then So these are the upcoming workshops, how to brief a senior advocate. This is tomorrow. Then you also have how to draft a bail application, sector workshops. You can have a look at these as well. When you click on register now, you get to see, so you can fill your name, etc. Who is this for? What you will learn. This is a story where I have talked about my experiences and what you will get out of the workshop, right? And then you can also have register for the webinars here. You can have a look. These are the webinars that are going to happen. Okay, this will be an important webinar. How does the Supreme Court judge scrutinize a petition and what to keep in mind while drafting it? Justice 𝗿𝗂𝗺𝗏 will be there with us. It's on 28th of January at 5 p.m. So this will be interesting. He'll be talking about what to keep in mind, what judges look at when they see petitions, what you should keep in mind while drafting it. So hearing it from a judge's mouth will be quite something. He's a retired Supreme Court judge. I've argued before him. He was extremely compassionate towards labor issues. Okay, then we have other webinars